Judgment in the appeal, the Queen on the application of the Public Law Project and the Lord Chancellor.
The judgment in this case is given by the President, Lord Neuberger, with whom I and the other 5 justices hearing the case agree. As he cannot be here today to explain our decision, he has asked me to do so. The Legal Aid, Sentencing and Punishment Act 2012, widely known as LASPO, made several important changes to the legal aid system. In particular, for the first time, it listed in an Act of Parliament the civil legal services for which legal aid would be available. Those services are listed by reference to their subject matter. For example, services in relation to special educational needs or loss of home and homelessness. The Act also gave the Lord Chancellor power to add to or vary or omit the services described in that list by delegated legislation. Powers given to a government minister to amend an Act of Parliament are sometimes known as Henry VIII clauses. Although the delegated legislation made by the Lord Chancellor for this purpose has to be approved by Parliament, it does not receive the same level of parliamentary scrutiny as does an Act of Parliament. In 2013, the then Lord Chancellor decided that he would use this power in order to introduce a residence test. People would only be eligible for civil legal aid if they were lawfully resident in the United Kingdom, Crown dependencies of Jersey, Guernsey, and the Isle of Man, or British overseas territories such as Gibraltar, when they applied, and had also been continuously so resident for the past 12 months. He laid a draft order to that effect before Parliament on the 31st of March 2014. The Public Law Project had already brought these proceedings, challenging the legality of the draft order on the grounds, first, that it was outside the powers which Parliament had given to the Lord Chancellor, and second, that it was unjustifiably discriminatory in its effect. After the order had been laid before Parliament, but before it had been approved, the Administrative Court held that it was unlawful on both grounds. The Lord Chancellor therefore withdrew the draft order from Parliament. However, he also appealed to the Court of Appeal, which allowed his appeal. The Public Law Project therefore appealed to this court. The court heard oral argument on the first ground on the 18th of April 2016 and indicated that it did not need to hear argument on the second, the discrimination ground. This meant that the appeal would be allowed and the draft order declared to be outside the powers given to the Lord Chancellor by Parliament. Today, the court gives its reasons for so deciding. They are simple. The Act gives the Lord Chancellor power to amend the list of services in the Act, but the draft order does not seek to vary the services listed. Rather, it reduces the class of people entitled to receive those services by reference to a personal characteristic which has nothing to do with the services listed. The services are listed by reference to a particular type of legal issue or claim, and not by reference to the characteristics of the person making or defending it. Not only that, the section giving the Lord Chancellor this power distinguishes between A, the services which qualify for legal aid, and B, the people who qualify for it, and expressly gives him the power only to vary A. This all shows that, when giving the Lord Chancellor this power, Parliament did not intend him to use it in this way. By declaring the order to be outside the power contained in the Act, the Court is thus upholding the supremacy of Parliament over the executive.